So we get asked relatively frequently under what circumstances a liquidator could ask a recipient of money to pay it back. So we're talking about a situation where a creditor provides goods or services to a company, it receives payment for those goods and services, the debtor company later goes into liquidation and a liquidator says, hey Mr. Creditor, please pay that back. Now, a liquidator can do that if there is a payment that is within 2 years of the liquidation date, so quite a long time actually, and that payment allowed that creditor to receive more than they would have in the liquidation of the company. The transaction has to be at a time that the debtor company was unable to pay its due debts. So we field questions that are, what if a liquidator takes this money back? How do I protect myself? So the starting point is cash is king. So take the cash, deal with the liquidator later. That's always my starting point. So don't be afraid to take the money, but at the same time you can do things to ensure you have lower chances of having to pay that money back. So there are defences to a liquidator's claim, and they're found in Section 296(3) of the Companies Act. So if the creditor acted in good faith, they had no suspicion of insolvency, nor would a reasonable person have suspicion, and they either gave value or altered their position, then they can have a good defence not to pay the money back. Ultimately, most of the cases will focus on did the creditor know that the company was insolvent, or should they? And if they did, then it can be very hard to resist a repayment claim. So one thing that you can do to avoid a liquidator's claim is by making the payment not a transaction of the company. Now, a few years back, the High Court delivered a decision that I don't agree with, but nonetheless it's there and it can be relied upon, that if, say, the director or the holding company were to enter into a deed of settlement with the creditor and they were to pay it through another entity by deed, then the transaction could be held not to be a transaction of the liquidated company and therefore not voidable. It's not something that can apply to all cases, but in some cases that could be available and is worth exploring if you think that debtor company may go into liquidation in the near future. So key takeout from this is cash is king, get paid, deal with the liquidator later, because there are defences. Don't get too hung up on the transaction at the time. If you've got any questions, drop them in the comments below. Cheers.